comply with international treaties. That is well and good. And also we, before we adopt something from international perspective, first we should see whether it should comply with our constitution. In India, our constitution is the supreme, you know, right? So not a prime minister, not a Supreme Court judge, or any other body, or president, or whatever may be. He is not supreme. In India, constitution is supreme. Constitution is written by Constituent Assembly. So all the laws and all the enforcement, all the legislative system and corresponding laws, everything is based on the Constitution of India. So that's the reason I said Constitution is supreme in India. So it should match with, before you bring, because we are studying about intellectual property, which is a law. So this law should comply with the Constitution of India. So what are the provisions that supports this intellectual property? That is the reason we enacted this Intellectual Property Act. Whatever the acts you wanna study in future classes, like Patent Act or copyright or trademark or whatever may be, all the laws, these laws are enacted in the Parliament, both upper house and lower house, and got the president consent. That's the reason we are studying these laws. And this is related to completely technological people. For example, coming to the patents, so mostly it is relevant to the science background people. So you are a computer science student, it is 100% relevant to you. So before we talk about these laws, so what is the constitutional provision? So why we enacted these laws, we should know about that. So there is a provision called in Indian Constitution. Indian Constitutions, there are so many articles are there. 51A, Article 300A. These are the two articles that supports this IP laws to be enacted in India. So our Constitution encourages scientific thinking and protects property rights. So right to property is a fundamental right earlier in our country. Now they made it as under Article 300A, which is not a fundamental right. So because these provisions are there, and this scientific temper word is, what does it mean by scientific temper, which we got it from Article 51A. So every person in India should have scientific temper. This actually word introduced by Jawaharlal Nehru. So while writing the constitution, so scientific temper means every person in India should think scientifically, and also Article 300A gives that it is a right to property. Article 300 gives, and it protects the property. So intellectual property also a one property. I already told there are tangible or intangible property. Tangible properties, you know that, you know, if you have land or if you have any flat or something, these are all tangible properties and which is protected by property law. And apart from that, this is the intangible property. So that's the reason, you know, intellectual property is a human creation. These things also will be protected. So because we have the Article 300A, which gives the right to protect the property. So intellectual property is also a property. That's the reason we enacted this law. So to for the purpose of scientific temper, and because we need to protect rights, property rights, as per the constitution. So we also enacted these laws. I'm just telling the brief history of how these laws came into the picture in India. So that's the reason I discussed about the constitutional basis. Due to develop duty to develop the spirit of inquiry and reform. Article 51 says our constitution prescribes a duty for citizens to have a scientific temper. Scientific temper means everybody in India should think scientifically. Develop the spirit of inquiry and reform. So constitutional entitlements to patents. I told already, like, you know, we have, since patents are considered property, you know, there is a positive constitutional entitlement. That's the reason we enacted this laws. And also in our constitution, we have DPSP, Directive Principles of State Policy, where it shows that this is actually non-enforceable. For example, in our country, if any product, this DPSP says that you should promote the public health and reduction of inequalities and all these things it will discuss in the constitution. So it is actually non-enforceable. In India, nobody can file that somebody government is not promoting the public health or any reduction of inequalities. You cannot go to the court and you cannot challenge. That's the reason these are non-enforceable. Because there are DPSP in our constitution, that's the reason we are coming up with intellectual property rights. I'm just telling that why we have brought intellectual property. What is the constitutional basis? As constitution is the supreme in our country. So that's the reason before you vote, you need to think, because these are the people who will enact our laws. Whatever the laws, whatever the rules we are learning or we are following. So everything is made by lawmakers. Before you exercise your franchise, before you exercise your vote, you need to think twice and vote. So next slide. So overview of the three distinctive periods in the Indian patent regime. So there are three periods in Indian patent regime. So one is colonial period. So during the British rule, colonial means. So that time, actually, Patent Act and Design Act both together. That both acts should be in a single act. That is called Indian Patent and Design Act 1911. And after post-independence in 1970, we made our own patent laws with Patent Act 1970. That is the Act 1970 Act. And after that, globalization in 1991, we opened up our economy and made changes to our patent laws. In 1991, that time, Prime Minister is P.V. Narasimha Rao. He is from Andhra Pradesh. So he actually brought globalization, LPG, liberation, privatization, globalization. During that time, we opened the gates. We started accepting the investment. If you want to start accepting the investment, if you want to have the trade, you should comply with the international agreements. That's how we are complied with international agreements, whatever may be TRIPS or GATT or whatever the agreements I discussed. That is the reason, because 1991 P.V. Narasimha Rao Garu, he brought this LPG. I mean, he brought the liberation and privatization, globalization, so that somebody can invest in our country, and our economy is not completely capitalistic economy. So when it goes to next slide. So post independence. So during the British era, we got an act, Patent and Design Act 1911, and after post independence, after we got independence, we actually put a committee, which is called Justice Rajagopal Iyengar Committee. So because we wanted to find out, is there any setbacks with the current patent law? So for that reason, he is a former Supreme Court judge. So we put a committee which is called Rajagopal Iyengar Committee. So socio-economic consideration leading to changes in patent law. These changes 1970 considered India's population based on the current population and economy that 1970 time, and based on that they have come up with 1991 we are compliant with the TRIPS agreement. So these TRIPS changes in 1970 we inculcated. So in 2005 those amendments came into the picture. We followed the TRIPS agreement and GATT agreement, and those changes we inculcated in the Patent Act 1970, and we brought the amendment. So the current act which you guys are learning or going through, that contains all the changes of international agreements, include those changes also inculcated in the current Patent Act 1970. So 2005 amendment brought that one. And also India is a pharmacy of the world. Before we bring this TRIPS changes, actually there was no product patents for pharmaceutical or food products. there is no patent product patents for especially agrochemical industry like pesticides and all, and also for pharmaceutical, because ours is a uh, generic manufacturer. Generic manufacturing is very high in our country. That's the reason our country also called the pharmacy of the world. So because of these reasons, because it is a pharmacy of the world, so if we start giving a patents, product patents on the medicines also, so we may lose, uh, we may get restricted. So those days we used to think like that. That's the reason before 2005 amendment, we don't have any product patents in the industry, pharma or food or agrochemicals. After 2005 amendment, that means after we are comply with the TRIPS or GATT, we have product patents in the field of, in all the fields, including pharmacy. So globalization and TRIPS, India's liberalization and adherence to GATT, that I already discussed during the PV Narasimha Rao time. Amendments to align with TRIPS agreement. I told 2005 what happened. Those TRIPS agreement, these are the international agreement. We are complied with that. And introduction of product patents in food, medicine, and agrochemical. Because TRIPS agreement or TRIPS agreement clearly says that you should bring product patent and process patent or product by process patent in all the fields. There is no exemption for some specific field. So we need to comply as we are a part of WTO. So we brought product patents even on the medicine also, apart from food and agrochemicals and others. So balancing flexibility, I told, right? So all the countries cannot have the same law because every country is in different, their economic situation are different and social inequalities are different. So many differences are there. So there are three kind of worlds. One is the developed, one is developing, and one is least developed. So for all the countries, same law, which is not feasible. So for that reason, in the TRIPS agreement, some minimum standards are everybody has to follow. Apart from that, some flexibility they have given. So based on the flexibility, based on the country's wish, they can change in terms of flexibility. That those flexibilities also in the further classes, which is very important. We're gonna discuss under section 3 of the Patent Act. Those are non-patentable subject matter. That is, we will discuss in the further classes, which will be taken by Ma'am Anindya Rai, Dr. Anindya Rai Chaudhary. So these flexibilities are there. That's the reason, though the same act, I mean, minimum standards that everybody has to follow, which is prescribed through TRIPS agreement, which we inculcate in our act, but still flexibility also we can inculcate, which we can implement through TRIPS agreement. TRIPS agreement gives the flexibilities also. So that is the reason we can, in the flexibilities area, we can modify our act. So, and also I told it took 10 years from 1995 to 2005 because all of a sudden all the companies in India or all the uh, innovators or creators or whomever come up with the intellectual property, they cannot all of a sudden come up with new changes. So it took 10 years, gradual systematic changes instead of sudden industry closures. This approach helped industries adapt over time. And also judicial review and constitutionality of patent related amendments, that also I discussed earlier. And also uh, even after TRIPS agreement, so we inculcated in 2005. So even after 2005 also, uh, we stopped one continuous patenting, so which is called evergreening. That is called, after you get a patent rights are 20 years. After 20 years also, uh, if you can come up with some incremental innovation, especially in the field of pharmaceutical, and these pharma companies are doing like that, and again they are asking for the patent. So if you start asking continuously patent, so which is not good for the society. So this continuous process of patenting, which without bringing a sufficient efficacy, so that means without much useful to the society. If you continuously patenting, that is called evergreening. Evergreening, you always patent. So these kind of things also through judicial pronouncement, which is the famous law, Novartis versus Union of India. So through this case law, we stopped evergreening. So, and also we said this kind of evergreening should be stopped, and this we inculcated in our Patent Act in section 3D. So that also we will be discussing in further classes. So curbing evergreening of patents while protecting incremental innovation. The code had to ensure fair rules, granting interim injunctions to protect patentee rights in pharmaceutical and agrochemical invention. So this I already discussed about this. And legal precedents. So legal precedents means like, whatever the Supreme Court of India gives, that that will be part of law. So these are the precedents. So through legal precedents, we have changes. We brought a good changes in intellectual property. So apart from this, we need to understand. So far, I talked about two international bodies. One is from WTO, one is from WIPO. WIPO is a World Intellectual Property Organization, which I told, which is there in Geneva, Switzerland. Actually, my LLM I did in WIPO. So this is the international body. These two bodies are very important in the field of intellectual property. World Trade Organization, WIPO. I already discussed through WTO, we got the we are compliant with the international agreements like TRIPS and GATT. And coming to the WIPO, we celebrate Intellectual Property Day. So that is World Intellectual Property Day. That is April 26th. That will be celebrated by WIPO all across the world. Apart from this, promotion and innovation and dissemination of the technology and promoting innovation and promotion of intellectual property, everything will be done by World Intellectual Property Organization. And also it administrated the international protocols, like whatever the treaties or protocols we are part of, we means India is a part of. So those treaties actually administrated by World Intellectual Property. So all these activities are done by World Intellectual Property. There are so many treaties are there. For example, every intellectual property, one international treaty will be there. If you take for patents, that is for Patent Cooperation Treaty, which is administrated by WIPO. All the treaties are administrated by WIPO, and also Paris Convention, which is also administrated by WIPO. If it is coming to patent, if it comes to trademark, if it comes to geographical indication and designs, for example, it is a Hague Treaty. So like that, all the treaties are administrated by WIPO. So these two bodies, you guys have to remember. WIPO, which is called World Intellectual Property Organization, and another one is called WTO, which is called World Trade Organization. So TRIPS agreement is from WTO. So that's all from my side, and hope you guys hope we floated an attendance sheet for this class as well. Anybody is there?
Yeah, we have another 15 minutes time. Students can interact with the faculty and get their doubts clarified. Attendance has been posted, huh?
Attendance has been posted. Dr. Aninja? Okay. Because nobody is giving.
Dr. Ananya, please post the attendance.
So if you guys have any questions, feel free to ask.
Either in the chat box or can also open your mic and also ask directly. Ananya, whoever is asking questions, that record should be there with us. We are, how do we get it? We can get the screenshots, or how do we know who has asked questions, who has not asked? There's some weightage we have provided 10 marks. So people who ask questions, I think they rewarded in those 10 marks. Dr. Anandya?
Anindya.
Anandya?
She's come.
How do we get the people who are asking questions to the recorder? You can get it. But, record has to be available. Yeah. Yeah, please start. Someone has to raise the doubt. First doubt raising only is the challenge. After that, many people will join in the wave. You see, Dr. Spoke about evaluation of IP system, you know. You can talk, ask anything on his talk or in general. Many doubts, you know. See, I don't like ask questions.
Sir, not audible.
Question may not be that great and all. Like that. Spoke about these three important aspects: WTO, TRIPS, WIPO. We also celebrate every year in Andhra University the World Intellectual Property Day, WIPO Day, you know, on 26th April, no?
Right, sir.
26th April. We invite legends in that area to address. Are you people are there? Online, 175 people are being shown here, but nobody is opening their mouth. You had your lunch now? You have not taken our lunch.
We
We
have not had
our
our
lunch for you people. Because time is so hard for us. Our time, actually, our lunch time is 1 to 2, but the class starts at 1:30. We have not gone for lunch. Subramaniam Gangisetti. His intellectual property rights are based on the Constitution of India. I think your question.
Very good. Who is this? Subramanian. Subramanian, the Gangisetti, yes.
Yeah,
Yeah,
good
thank
question.
you for, yeah, it's very good question. Thank you for asking. So, intellectual property rights, yes, it is every law that is created by India, there should be constitutional support should be there. So, if there is no constitution, because constitution is supreme in our country, so it's not that president or Supreme Court judge or whatever may be, they are not the. So, our constitution is supreme. Unless there is a support from Constitution of India, so we cannot create any law, including intellectual property rights. So for this, Article 51A and Article 300A. So Article 300 talks about right to property. So because intellectual property also a right, it's a, so that's the reason we are protecting intellectual property rights, which is the tangible rights. And Article 51A, scientific temperament, like every Indian have that feeling, scientific temperament. So for that reason, we have enacted this intellectual property rights. Subramaniam Gangisetti. Thank you for asking this question. Hope this clarifies.
Preamble, you know, the preamble of the Constitution, there was a mention about this as Ashok said, property, you know, is a fundamental right, property protection and.
No, property is right to property is not a fundamental right. Earlier it was a fundamental right. They moved it to constitutional right. Now it is under Article 300. So preamble is different. Preamble is different. It is there in article 300 and article 51.
Yeah, 50, no? 51.
So which gives the constitutional basis for having intellectual property.
Yeah.
This everybody should know because we are part of this country.
What is 332? Madhu?
332. What does it mean? So you mean to say 300, article 300.
Article 300.
Property right. 300. This is the property right. Property right is the
Property right means, as we were talking, property means it is both takes care or it covers both tangible and intangible. So IP is an intangible. Ashok, there is a question. Vandana.
Sir, if we play a patent in India, yeah, this is a very good question. Who is this? Vandana. So actually, patent is any IP right. Actually, that is given by our Indian government. So whatever it gives Indian government, it is valid in India only. Because the sovereignty of India, because what our preamble says, India is a sovereign socialist republic country, republic and secular country. So because the sovereignty exists only in India, the right is given by India because you have come up with the invention and that invention needs to be protected. So that's the reason you file a patent, and because you file a patent, after 18 months it will be published because you are sharing the invention to all the public, and in return you are getting this right, which is exclusive right, which is a negative right. You can exclude others from making, using, selling, and importing of this patent, this invention. So that is the reason this is only valid in India. If you want to get this patent, this right in other countries, for example, US or Japan, for example, if your invention is having potential in other countries as well, yes, you can do that, but provided you have to file in a different countries, whichever country you feel that there is a potential with your patent or invention. So definitely you can do that through PCT or Paris Convention. You can do that. But for now, if you file a patent in India, so that is whatever the right that is given by Indian government, it is valid in India only. Because the right is given by India, Indian sovereignty is limited to India only. Hope this clarify your question. Vandana. So very good one.
Yeah, in the subsequent classes, the differences of filing patent in India and other countries, the channels available, all those things will be taught to you. But it's good that you are able to visualize and asking a good question. Now, patent rights are territorial rights. That's what Ashok was saying. Territorial rights means if patent is granted in India, you get protection only in India. If you want to get protection in other countries as well, you need to file patent in those countries. No, then it will be examined as per their country's rules. Mostly the rules are 99.9% same. So they have a prosecution process, then they will grant. So it's not possible to get patent protection in other countries unless you seek the protection in those countries and it is approved by those countries.
And there is another question. Yeah. There is another question. Dandu Raghavendra Varma. For logos, software can we have trademark also limited to India market or not? Yeah, for example, as I told, intellectual property rights are territorial because these rights are given by Indian government. So unless you file in their countries, whichever country you wanted to protect, for example, you are saying logo. Logo is for any company logo. For example, if you take Pepsi or Coca-Cola or Samsung or whatever may be logos, these logos uh, represents one company. So why they wanted to file a trademark for this logo? Because they wanted to protect the reputation and their goodwill. So by seeing that only you will go and buy their product. So unless you file in their respective countries and try to protect your goodwill and reputation, it cannot be protected in other countries. For example, if you want to protect in other countries for trademarks, there is a protocol that is called Madrid Protocol. So India is a treaty. India is a member of Madrid Protocol. So through Madrid Protocol, you can, whoever is the member, whoever is the signatory of Madrid Protocol, they also can, you can file a trademark in those countries and you will get protection of your goodwill and reputation. So software can be protected two ways. One is copyright and another one is patent. In the software, if you can show technical effect, then it is patentable also. And software can be protected through copyright as well. And patent also, I told, international agreements are there, treaties are there, so that you can protect your software. That means either might be a copyright or invention. You can protect it through multilateral treaties are there. If India is a part of that multilateral treaty, yes, you can file it there and you can get it protected. For coming to the software, automatically it is protected as long as you fixed that software, fixed in some intangible medium. For example, any floppy disk or something. The moment you keep there, then your rights will be, you will get your rights. So coming to the trademark, coming to the patent or invention, you can file through multilateral treaty, VC or Paris Convention. So hope this clarify your question. Turn to Raghavendra.
Another additional information to the students. No, for example, you have a product. The product can have more than protected through more than even one IP also. If there are more number of IPs through which the product is protected, it will be more robust and it's difficult for others to infringe or copy. For example, if you take a simple toothpaste, what we are using, so the toothpaste has got, more than I think 3 or 4 IPs are embedded in that. No, the composition of the paste is a patent, protected through patent. No, the tube is protected through design. Similarly, the way they write, on the Colgate or whatever name, the particular style, it can be the language, the English, what they write is protected through copyright. Even the trademark, Colgate is a trademark, So like that, the same simple toothpaste is protected through more than one intellectual property right, such as patent, trademark, copyright, design. You see, so the more number of IPs are embedded, it is more stubborn and more difficult for others to infringe or copy your IP. It is not necessary that it should be protected only any one of the IPs. It can be even more than one IP also. Any other question? I think Ashok, they have given one more. Dando Raghavendra Verma.
You see the copyrighted, right? You see the copyrighted by XYZ organization also need to be.
Can answer also.
Or copyright, as I said earlier, copyright is automatically protected. So copyright protection, for example, if any infringement happens, if somebody copies your copyrighted work, original work, then if you want to sue them for that purpose, you need to resort to the courts. So if you want to enforce your right, for that purpose, if you have registration, that you can show it as a prima facie evidence. That is the basic evidence. Before you file any FIR, the police station, they ask prima facie evidence. In the same way, if you have the copyright registration, it will act as a prima facie evidence. So apart from that, if you, the moment you fixed your copyright in any intangible medium, so your copyright is protected. That means copyright is automatically protected. But if you want to enforce your copyright, the right which you have on that particular art, so for that reason, you may need to register. So another question is from Pranati Allu. Sir, if a brand changes their logo, is the present extended for another 20 years? Actually, for trademark, it is 10 years and which will be renewed provided if you pay the renewal fees is continuously, and it is infinite. Actually, this 20 years term is for patent. Patent protects the innovation and copyright protects the expression. It won't protect the idea. And trademark protects the goodwill and reputation. See, for example, if you go to the store and by seeing their goodwill and reputation, you gonna buy some paste or some biscuit packet or whatever may be. So by seeing the reputation and goodwill, you're gonna buy. So that will be protected by trademark. So that's the reason they put a trademark there. If you see any Coca-Cola or anything, if you see any mobile or something, Samsung or Apple, by seeing the trademark, you see that, oh, reputation, goodwill is good, then I gonna buy. So trademark is protected only for this goodwill or reputation, protected for 10 years, and you can indefinitely renew it by you can.
మీకు పంపిస్తాను, నాకు హాయ్ పెట్టండి, మెసేజ్ పెట్టండి, ఆ ప్రాసెస్ అంతా పంపిస్తాను.
Hope this
ముందు
clarifies.
రిజిస్టర్ చేసేయండి. చేసేసిన తర్వాత మనిషి 300 చెప్పుకున్న డిడిఓ లేకపోతే మా బ్యాంక్ అకౌంట్ కు ట్రాన్స్ఫర్ చేసేయండి. ఆయన పెట్టండి, మీకు ప్రాసెస్ అంతా పంపిస్తాను, తొందరగా చేయించండి. రైట్. ఏం పేరు మీ పేరు? మీ పేరు కూడా పెట్టండి, అందులో సేవ్ చేసుకుంటుంది. ఓకే
Sir, another question is that for logo software, can we have it? Yeah, I think, sir, what is evergreen? Very good. From Kannuri Devanarayana. Sai. Evergreening means once you file a patent and you will be given 20 years for the protection of your invention, provided if you satisfy all the patent office conditions. Like non-patentable subject matter, novelty, inventive step, and industrial application. Once it is done, you will get the patent, and that is valid for next 20 years since from date of PRP, whichever is earlier. So apart from that, so after you complete 20 years, especially some pharmaceutical patents, pharmaceutical companies, what they are doing is just they are bringing some incremental innovation, like which is not substantial and which is not having much efficacy, and they are filing the same thing and asking for next 20 years, saying that this is having this is the new another invention. So to stop that, that is called evergreening. So continuously that patent will be protected. Normally patent is a limited right. Okay, that is a patent is a quid pro quo. So you are disclosing the invention to the public. In a return, government is giving a right to you, and that is a limited right, though that is exclusive. So if you start giving this right forever after 20 years also, so that is called evergreen. Continuously, you are filing and getting the protection. So in that way, it is not good for the society. It is not going to benefit for society. You are continuously claiming and you are continuously monopolizing the specific invention, which is not allowed. Hope this clarifies. Kannuri Deva, Narayana side.
And also, just giving one idea to the students, you just in the interview, if you see the interview members, they will ask questions on what you speak, in your answers, if you say something on the test your knowledge, they will ask questions on what you spoke before the committee members. Here also the same analogy can apply to generate more questions. If you listen carefully, like the gentleman raised evergreening, it's a good question. Many people, they do not know what is meant by evergreening. But Ashok has mentioned in his talk evergreening. So this gentleman, Kannuri Devanarayan, has caught that terminology, that word, and raised very relevant question. It's very, very important topic in the entire pharmaceutical patents, evergreening. The countries in the world are fighting, to protect their, extend their patent life by filing an improvements over the existing granted patent, so that they will be there forever. Is evergreening is such a vibrant topic. One can talk hours together on the evergreening, but at least you should know what do you mean by evergreening, which field it is applicable. So like that, you just listen to the guest faculty and catch some of this terminology, what they spoke, and you can raise that, the question answer session. By that way, you also get educated, even other members of your class also are got educated by your question. So that is what just the point I would like to mention to you. You don't have to break your head to formulate a question and ask questions. If you listen carefully to the lecturer or the speaker and note down some of the key points what he was mentioning. So, for
And
example,
there
we
is a-
talked about
Yeah,
TRIPS,
there is
WIPO, and all those things. One can ask many questions on that, but only thing is you need to have that kind of a open mindedness, curiosity, very, very important. Yeah.
And there is another question: how long does it take before books are considered to be part of the public domain? Will they be free in the public domain and therefore free to distribute? See, actually, the books are protected by the copyright. Copyright normally it is a life of the author plus 60 years. That means after author dies, still 60 more years that will be protected. His copyright will be available. So after that, it will get into the public domain. So that's what I have written. For new drugs, another question from Dandu Raghavendra. For new drugs or chemical formula also have patent of 10 or 20 years. Yeah, any product or process patent is having 20 years. And copyright is for lifetime. Okay, that I will.
Patents are given across the world only for 20 years, not 10 years. All patents are granted for 20 years if they fulfill the criteria of the patentability, novelty, inventive step in industrial use. So when it comes, you people should ask more questions to how do you define novelty, how do you assess novelty, how to define inventive step, how do you assess in a given patent application the inventive step. So all these basic questions you people should ask. Only requirement is attention and opening up your mind. Then you will find a large number of questions on any given topic. Okay, if there are no questions, probably we can close the session because the time given to us is over. I hope all of you have filled your attendance sheet in the Google form, which was posted in the group here, the chat box. Please submit your attendance. You should also remember, if you want to appear for this examination, like other subjects, you need to have minimum 75% attendance. Then only you will be allowed to write the examination. Otherwise, you will not. And you have to be treated as per the university norms. Anandya, you have any announcements? Dr. Anandya, you want to say something? Any announcements? No, you are on mute. Open your mic. You are on mute, Anandya. Yeah, if there are any questions, we can spend some time. If there are no questions, we can close it. Okay, then if there are no questions, you will have your next class on coming Saturday. That is on 30th, no? 30th. The timetable, the schedule of the class was also shared. Please, all the CRs, one more important announcement is that the CRs are going to play a very important role in this entire program, in online programs, because we don't have access directly to the students. Only through CRs only we are able to reach you out. So you should be in touch with your CRs to get the link shared. We send the link only to the CRs. The CRs in turn should share the link with all their classmates. So CRs play a very, very important role in making this program successful. I request all the CRs to proactively engage themselves, with your classmates and the IPR center here to get the maximum benefit out of this class. Okay, if there are no questions, then we can close it and see you on Saturday, next coming Saturday. But I see there are about 700, 800 students are there as per the 9 sections. Only today maximum was about 187, 189. I've already reported to the HOD, but please see us, please ensure that the number of participants should be there. Otherwise, you will not get your degree. That you please remember. Then you have to run from pillar to post to get all the clearances, approvals. I don't know what kind of hurdles will come on the way. So instead of that, better to attend the class regularly and don't invite problems for yourself.
Somebody is asking. Someone of you, you are asking for laterals roll number. We have not issued attendance. So we want to know how you want the attendance form. But you will be in some of those group, right? 2x4, 2x6 or something like that. What is the problem you are facing over there? Chandrasekhar.
Mr. Chandrasekhar, we don't differentiate whether you are a lateral entry or a regular MSET entry. The department has sent all the names to us section wise. Now we compare only with that. So there is no difference whether you are a lateral or non-lateral. As far as attendance is concerned, the Google sheet is given to you. You fill your details and submit it.
But there is no email ID for us which is recognized by Andhra University, sir.
Okay, no problem. You write whatever you have.
You have no problem.
Okay, ma'am.
Once you submit, we will get your attendance sheet. So we compare with your registration number there.
Your registration number is important.
Okay, Chandrasekhar? Mr. Chandrasekhar, is it okay?
Okay, sir. Thank you.
Yeah, if you have got any doubts, you can come here. South Campus, your AU Computer Center, ground floor, we are here. Any one of you have got any problem, any doubt, you are always welcome. Not only on Saturdays we should meet, even other days also we can meet here. We are all available here to help you, to guide you. If any one of you are interested to do some internship also, you can come here. So you will get some experience, exposure, and some soft skills you will be able to develop. We can accommodate 3-4 students as interns. This can be treated as an internship as per the university norms also. Even otherwise also, it will be a good learning opportunity for the students. So think and make use of your time properly. Don't waste your time on unnecessary pursuits. Acquire as much knowledge as possible when you are a student here in all dimensions. Okay? Okay, all the best. Raise questions, raise doubts. That is what is important in life. That is how you acquire knowledge. Status quo, why not this, why not that? But in a humble manner, with a learning attitude, not to test the knowledge of the faculty, Okay, then have a good day and good weekend. Thank you. I'm exiting.